Welcome. In this video, we will discuss about the latest finding by the Parliamentary Standing Committee on Science and Technology. They have raised a lot of red flags in terms of the DNA bill how it could be misused. So this is the context in which you have to understand why the DNA bill was proposed and what kind of concern has been raised by the committee. So let's begin. First of all, let's try to understand the context. So the bill that proposes DNA sampling and profiling of citizens accused of crime or reported missing and storing their unique genetic information for administrative purposes has some alarming provision that could be misused or for a particular caste or individual. So just look at the main provision. So basically this DNA profile bill, what it will does, it will kind of have your DNA collected. For whom that DNA would be collected, it would be for the people who are offenders. So they are the one who have been booked under some kind of activity. They will be the offenders and they will be booked under this bill. So what this particular parliamentary committee has flagged, that such kind of DNA profiling and certain provision of this act are worrisome and could be used for targeting particular individual or community. So these are some red flags which has been raised. Now, the DNA Technology Use and Application Regulation Act of 2019 has been in the works of 15 years. So this is not something new which has come up for the government to work on or the investigation agency which has asked for. This is something which has been going on for as back as 15 years now. So a lot of time has been gone into the deliberation that whether do we need a DNA bill to begin with or not. And India is not the only country to have such kind of bill. Already around 60 countries have enacted similar legislation, and US is kind of the foremost which has such kind of law way back in 1994. So if you have been watching the English TV series, the crime thriller Criminal Mind or such like that, you would have seen that how they go for the database search of DNA, like how the fingerprint would be matched with the database of the DNA collected for various people. So such kind of things has been used in other countries as well, and particularly in 2019 Indian government has also come up with the bill. But we have to be cautious that how this bill could be used against the particular community or an individual. So let's just see what is the concern which has been raised by the committee. So the first of all, they have raised that under the provision of the bill, access to such intrusive information can be used specifically to target individual and their families with their own genetic data. So just for an example, if there is the people who are maintaining the databases, if they have some kind of grudge against an individual and that DNA is caught, so such kind of things could lead to a scenario where particular individual or even their families is targeted. So this is something which the committee is concerned about, that bill does not provide any safeguard regarding that. Now, the report also red flagged disregard to individual privacy and other safeguard. So, there is a clause of written consent when collecting the what you can say the DNA sample, but a lot of keywords have been associated with it, and overriding power has been given to DM, so that it's like even though it's the consent is there, the consent is actually per functionary, which means that even though the in clauses written consent is required, but if you go around it, it is like on ground it is very easy to override such kind of consent. Another thing which is kind of provide for is to store DNA profile of suspects under trial, victims and their relative for future investigation. Now this is actually a huge ambit, that you are going for the suspects under trial, victims and their relative. A lot of information is actually gathered in terms of DNA, and which is a very sensitive information. So you have to understand this whole information with related to DNA is pretty what you can say sensitive in terms of it reveals the health status, it reveals the other kind of information which people in general sense or in their right to privacy would not want to be revealed. So these are the few things which committee again highlighted. In the bill, if a person is arrested for an offence that carries punishment more than 7 years, investigation authority must take the person written consent before taking the DNA sample. So like for what it is being said, up to 7 years, not more than 7 years. So it's like for any criminal offense that you have conducted, if the punishment is up to 7 years, you have to, the authorities who are collecting your DNA sample has to get your consent. So like again, as mentioned earlier, you have to provide the consent if the criminal offense punishment is lesser than 7 years. Now if it is more than 7 years, such kind of requirement does not exist. But even for this particular 7-year clause which is there in terms of punishment for a criminal offense, the DM, the district magistrate, has been given the overriding power. So now in essence or in ground, what is happening, that it is pretty easy for the authorities to go ahead and collect your DNA even when there is no consent. So this is one another thing which this committee says need to be worked upon. Now there is also no guidance in the bill on grounds and reason of when the magistrate can override consent. Now this is actually very tricky. Like if you really look into it, the first of all, you have given the overriding power for the DM to let go of the consent part, and you have also not specified the reason. So it's like he can work on his whims and does not have to specify any reason why he went ahead and overrided the consent requirement for collection of DNA sample. The bill permits retention of DNA found at crime scene in perpetuity. Now this is also very troublesome. Like the DNA will be with them in perpetuity, even though when the court has already acquitted you of the crime. So which means that there is a huge scope for misuse. The bill also provides that DNA profile for civil matters will also be stored in the data banks. Now this again goes against the whole purpose of DNA. Like for your criminal matter, it still makes some sense to have the DNA profiling, but for civil matters, for an example, the theft or this other civil matter including the divorce and all, why the DNA sampling is required over here. So that is again few of the concern which has been raised by the committee with related to the DNA bill which has been proposed in 2019. Now let's just try to see the main provision which were made. So first of all, just remember it is still a bill, which means that it was with the parliamentary committee and they were kind of scrutinizing its provision and seeing how feasible or how equitable and inclusive it is in its application. So this is where it is still a bill under discussion. The bill seeks to establish a national data bank and regional DNA data bank. So there will be at the level of nation there will be data bank, and at the regional level also there will be data banks. It envisaged that every data bank will maintain indices like crime scene indices, suspects or under trial indices, offenders indices, missing person indices. So basically the idea behind is you don't club everything all together and have different indexes so that it becomes easier to search. For an example, offender index should not be what you can say mixed with the missing person index, otherwise the search itself will become very troublesome. So this is something which a bill takes care of. It says that we should have different indices for all the different kind of criminal activities or different kind of section that is required to be covered within the DNA bill. It also seeks to establish a DNA regulatory board. Now because DNA sampling requires a lot of collection of sensitive information and it's kind of something which is very private data of an individual, regulatory board was required. So this bill suggests that we have a DNA regulatory board, and any laboratory which is like collecting the DNA sample has to be recognized by this regulatory board. So this is the major provision, that the laboratory has to be like approved by the regulatory board, and then only it is legalized for collection of DNA sample. The bill also proposes a written consent by individual to be obtained before collection of DNA sample. As mentioned earlier, like if the crime against which the criminal punishment is up to 7 years, a written consent need to be collected from the individual before collecting the sample. It also provides for the removal of DNA profile of suspect on the filing of a police report or court order. So as mentioned earlier in the flags which committee raised, that it is by default will store the information in perpetuity, but there is a provision that you can file a police order or a court order and get the your DNA sample data removed from the data bank. So such provision is there. But if you see at the whole, by default it is stored in perpetuity, which means that again it is on the individual to go ahead and ask for the removal of data even if they have been acquitted by the court. So these are the few provisions which are there in DNA Technology Use and Application Regulation Bill of 2019. Now, why this bill was proposed? Because there has been a lot of cases of missing people, non-identification of diseased bodies. So these are the major areas which could be solved if DNA database is in place. So because of it, it is important that we have some kind of bill to regulate the whole framework, but at the same time we have to make sure that the privacy concern as well as the rights of the individuals are also honored. So I hope you have understood this video. If you have any doubt, please feel free to comment in the section. Thank you.